If you're considering buying a property with your partner, then you need to watch this video. Today, we're going to break down all the considerations you need to think about if you're buying with your de facto partner or spouse. We're going to run through the lending implications, what it means now and in the future. We're going to go through some of the legal implications, what happens if something goes wrong at the end, if there's death, different things like that. You need to watch this video if you're considering buying with a partner. So let's start from the top. Nathan, how does a bank even define your de facto partner? Who is considered a partner in this situation?
Yeah, look, the banks are really funny in terms of the way they view what a de facto relationship is. The government technically declares a de facto relationship as a party living together for 2 years. Not in the bank's eyes. The banks will consider you in a de facto relationship if you've been living with your partner for at least 3 months, or if you have intent on living with your partner in the future.
This has a lot of implications, not just if you're buying a property together, but if you're buying on your own. We've had situations where a single applicant might be applying, they could be living with their partner, and they state on the application that they're a de facto. In the bank's eyes, they're no longer just Jaden, the single person paying for his own bills. Unfortunately, they're saying, well, it's Jaden, the de facto, who's looking after your living expenses of 2 adults. And this can reduce your borrowing capacity. So that's where it works. Even with your partner, it's worth sort of sorting that out at the beginning and having a pretty frank conversation with your mortgage broker to work out what kind of implications is going to have on your borrowing capacity.
Now, as Jaden said, if you're considered de facto, your living expenses might increase from maybe $1,900 a month to $3,000 a month, which is why your borrowing power comes down. Now, not all banks are the same in the way they view this. There's some lenders that say if Jaden's de facto partner is working, well, they're looking after themselves financially, so then the living expenses aren't $3,000, they might only be that $1,900. So it pays to work with the mortgage broker here.
But back on the topic at hand, if you're buying with a partner, you're buying a property together, the banks see everything as joint and wholly liable. So if Nathan and I are partners, for example, we're buying a property together, when we do the application, they don't really look at Nathan's savings, they don't look at my savings, they don't look at his credit cards, my car loan. It's all the one thing. And this makes it really good because it can mean your borrowing capacity combined is way better. It can mean Nathan can contribute the whole deposit and I can contribute a higher income and pay for the loan, but it also it causes issues at the back end when you might go to separate, you might go to sell the property. Nathan said, well, I put in 100,000, you put in nothing. I want my $100,000 back first. The banks don't really care. So this is where you need to have a legal conversation up front, which we'll come back to. But as far as the loan structure, Nathan, talk us through the different ways that you can look at this, because by default, the bank looks at the one property, they'll give you one loan, and you're both responsible for that one loan.
Yeah, look, and in this situation where Jaden and his partners borrowed together and the relationship splits and you haven't quite sold the property yet, if one party decides not to pay the loan because the loan is joint and severably liable, in that situation, both credit files will be affected. If one party stops paying, the other party can't meet the repayments, then your credit file goes down. So one quick solution here is looking at a structure called property share. Now, this isn't something that a lot of banks do, but there are some lenders that can offer it where effectively Jaden gets a loan on his name only, with him getting guarantored by his partner, because the property is owned by both parties and Jaden can apply for a loan on his own, and then his partner can apply on their own, so they cross-guarantee each other.
So practically speaking, say if you bought a property with your partner for $500,000, typically you get a loan of $400,000 and the loan is in both names. In this property share model, the bank cuts that $400,000 in 2 parts. Partner A gets $200, partner B gets $200, and you're both individually responsible for those individual parts of the loan. So the nice thing is, if you bust up, if you separate, only you're responsible for the $200,000 and the partner's responsible for that. If they stop paying, it's kind of their responsibility. Still guaranteed by your property, but it helps protect you in that situation.
Now, the other thing to consider is if you are going to buy a property with your partner and you don't want to do the property share, you want to start with baby steps. So maybe you share a joint bank account to begin with. Maybe you start getting your finances intertwined from the shared account through your shared savings, all those sort of things, so you can sort of feel it out, see what it's like. If you do decide that maybe buying with your partner, it might be too early in the relationship, it might be wise to buy on your own. As we said, you can still get loans on your own, and there's still lenders that would consider you single from a financial point of view and a borrowing capability. But Jaden, if you did buy a property with your partner and say I was contributing all of the deposit, are there ways you can structure the ownership so in the event of a sale, I'll get more of the percentage of the property back? Or how does that work?
Yeah, there's typically two methods of being able to buy when you're buying a joint property. There's tenants in common and joint tenants. Now, before we get into the section, I'm going to really heavily caveat and say you need to get legal advice. This is general advice only that we're going to go through in this video. So if you are considering a structure, sit down with a lawyer. It pays to sort this out because there are heaps of implications. But in Australia, there's pretty much two types of buying properties and two methods that you need to decide. So joint tenancy is a method of owning a property which allows sort of both people to have their name on the title. So me and my partner to be on title. And the effect of joint tenancy is that upon the death of, if your partner dies, there's a legal process where it pretty much gets transferred. The ownership gets transferred to the surviving person, and you don't have to pay stamp duty and stuff like that. There's no need to transfer and extra costs, etc. But I guess the downside with this structure is that if you can't really sell your interest, that you both own the property jointly, equally, and if I put in more deposit than my partner, it doesn't really get reflected in that sort of joint tenant structure. The second structure that you can look at is tenants in common. And that's where you and your partner own a property and you actually have shares. You can specify it. So you can say, well, I've put in 90% of the deposit. So I'm going to have 90% of the shares in tenants in common and my partner's going to have 10%. And then when you die, there's obviously different ways of transferring because it's different ownership proportions. But equally, when you sell, then I'm owning 90%, the partner's owning 10%. So that can be a more equitable way of doing it if you're potentially doing different equity contributions, different contributions of deposit, and more fair because then you don't need to worry about other legal agreements like a binding financial agreement or getting other things to work out, well, although we're joint tenants, I put in more deposit and if something happens, I deserve more of it. So again, it's pretty heavy subject to have a chat with when you're buying a property. It's all exciting, all things going well, but you want to do it up front because there are massive stamp duty, there's costs, and there's even issues at time of separation that you need to address then. From the bank's perspective, generally speaking, as long as you're both living in the property, they're okay with ownership proportions. If it's like Nathan and I buying, they potentially want a minimum of 30% ownership in the property, but it gets more complicated with that.
And if you do find value in our video, please consider hitting that subscribe button as it does really help out the channel. And a big thank you to our subscribers for your support inspires us to create more content. So Jaden, we've talked a bit more about the lending setup. From a legal point of view, what should I be aware of when buying with my partner? What are the things I need to be careful of?
Where I usually see it come undone, if you're putting in joint amounts, if you're putting in the same amount of deposit, your income's roughly the same, it usually works out pretty good if something goes wrong. Where I've seen it go wrong, and we've had clients that are in this situation, is where one of the partners might be putting in way more deposit. One of the partners might have parents gifting the deposit and the other partner is contributing nothing. Usually there'll be issues at the back end if something goes wrong, even when they're going to sell the property and working out who gets what. So I think for that reason, it's worth having a pretty uncomfortable but honest conversation up front, way before you start looking at properties, way before you look at open homes. If you work out, well, Nathan's parents are contributing this much and the partner's parents are doing nothing, or vice versa, well, maybe it's more fair to do the split this way, or maybe we need to have an agreement saying that the parents get paid back on the sale of the property. Having that conversation up front is just going to avoid legal issues down the track.
And this is where it's really important to get an assessment done, maybe get legal advice and have something in writing before you buy the property. You might say that because I'm putting in more deposit, I'm going to have more percentage on the ownership, but in the event of the sale, what does this look like? Who gets the first dibs at buying the other party out? Or is it going to just go straight to market? How are you going to determine the valuation? How are you going to really square things away? And even the ongoing costs. What if one party's paying all the mortgage, the other party's paying for living expenses? All those things you need to consider, and it's really important to get legal advice and make sure you're aware of your implications with this purchase, both now and in the future, especially if a split were to occur.
So recapping, buying with a partner can be an excellent way of potentially increasing your borrowing capacity, getting into the market and getting more house for your money. But you really want to think about some of those legal aspects, working out how the loan, the title is going to be structured. If the bank have other structures, if you're potentially not going to be with them longer term, or there's different things, try and consider that. And if you are getting help from friends or family with the gift, try and work out what happens if you can't sell the house. What happens if you can't pay them back? Is it going to be non-refundable? That's the bank's preferred sort of structure. But all these conversations need to be held up front, so at least you know what's going to happen in the future.
Did you know here at Hunter Galloway, we help many couples buy their dream home? So reach out with us directly. We're a mortgage broker that deal with people Australia-wide. Call us directly on 1300 088 065 or visit our website huntergalloway.com.au, and we'll see you next time.